There
There you
we
go, Scott.
go. Good afternoon, folks. My name is Schuyler Hoffman, founding partner of Hoffman and Forde. Uh, Born and raised San Diego native. Essentially lived here my entire life. I did a scope in North Carolina for undergraduate, worked on the Hill in DC for a while, and I got into the legal profession because, believe it or not, political life was even dirtier. Um, but been working with Brad for maybe 5 years now, Brad, perhaps a bit more.
Maybe even a bit
Um,
more.
yeah, well, time flies when you're having fun, right? So ultimately, Hoffman and Forde, full service boutique firm. We do everything real estate related, from a small landlord tenant dispute to acquisition of an apartment complex, essentially retail, industrial, mortgage litigation. So there's two parts of us. My side is the residential real estate. My partner, Dan Forde, primarily handles our commercial real estate. And then we have a bunch of associate attorneys that handle everything from fair credit reporting to estate planning, to entity formation, corporate work, HOA work. So we pretty much run the gamut. And what I've told Brad, and what I've told all of the agents that I represent, that I keep a pretty solid network of contacts throughout San Diego. Um, it, there's a misconception among lawyers that, oh, I got a DUI. Oh, I better call Sky. Well, that's great. I can find you a good DUI lawyer that I can tell you, I can guarantee you'll do a good job at a reasonable price. But at the end of the day, the law itself is too broad for somebody, regardless of how smart and how long they've been doing it, to know it all. So my specific focus is on residential real estate, both transactional and the litigation facet of it, and everything that balloons from that. And if it's outside the scope of my law firm's expertise, I can always guarantee you that I'll get back promptly with a good referral of somebody that I would use if I was in your shoes.
And in
So,
my opinion, Sky is like the best in the biz, in his biz. I would go to no one else for anything else. I trust you that much. I mean, he is my lawyer of choice when it comes to anything real estate related.
well, again, I appreciate that, Brad. At the end of the day, there's a lot of lawyers to choose from. There's a lot of real estate agents to choose from. What it comes down to is it comes down to knowing your profession, being professional, and about relationships. And so, again, Brad and I have always had good interactions because, one, Brad knows that I'll take good care of his clients, and I know that when I send Brad over to somebody, they're going to get that equal, white glove treatment. So, as it relates to what's going on with COVID, what's interesting about COVID is that there's about 2,500 quote unquote real estate attorneys in San Diego County. Okay. And there's San Diego County Bar Association has a real estate property subcategory. And there's a blog wherein we're all able to communicate with one another about specific real estate issues as they come up. So what's been interesting within our subcategory is we've all been inquiring with each other about what's called force majeure, which is codified to a degree in Civil Code 1511. But force majeure ultimately is the theory of act of God, that at a certain point you're in a contract, party A and party B, that perhaps one party can breach that contract or withdraw from an obligation under that contract, under the theory that has nothing to do with what party B did or didn't do, but with the fact that external forces, quote unquote, acts of God, if you will, have made it impossible for party A to perform under that contract. Now, what's even more interesting is living in San Diego. If we all lived in Oklahoma, I could give you a very simple force majeure example, okay? Brad's representing a buyer in escrow to purchase a property in Oklahoma, okay? We're set to close next Friday. Tomorrow, a tornado blows through and destroys the property, okay? That's a force majeure situation where buyer's not obligated to move forward and buy that house, despite the fact they may have released all contingencies. But what's interesting is San Diego. knock on wood, we're well overdue for an earthquake, and a big one. So guys, make sure, side note, get your earthquake insurance. I scream at Brad every time I see him, make sure your clients have earthquake policy insurance. Okay. But that aside, we have not in the last 30 years had any calamity nearly to the degree of what we're seeing here. So there's very little applicable case law. And why is that important? It's the reason that's important is because the civil code says what the civil code says, but it's tough to envision this, but the civil code really isn't the law. And what I mean by that is the law is a court's interpretation of the civil code itself. So that's why case law is so important. That's why a lawyer will tell you, okay, here's Civil Code 1511, and here's the applicable case law, and here's how it compares to our fact pattern. Well, the cases that we're citing and that we're having to research right now are from 1940 to 1945. Well, what happened back then? Essentially, it was when we were in the middle of World War II, and you had businesses shut down because of the Defense Production Act was enacted during that time by the then president, and businesses were no longer able to function. They were required to either shut down or to convert to a military production capacity. So it's pretty darn novel for 2,500 lawyers to be referring to case law all the way back to 1940 on something like this. Now, what's equally interesting with COVID and with insurance policies in general, thank you. There's my demand letter, folks. What's equally interesting about COVID is what I'll tell you about insurance policies is, generally speaking, the smartest people in the room are the actuaries that work for these insurance carriers. And what do I mean by that? The one group of people that I can guarantee you foresaw COVID, what we're dealing with now, and the extent of it on the economy was the actuaries for these insurance carriers. Why do I say that? Is because a couple years back when we were dealing with Ebola and a couple other viruses that occurred before that, all of a sudden in these business interruption insurance policies that a lot of businesses own, you start seeing a new exception come up. And that exception was for viruses. And that hadn't been there prior. But because those prior viruses were nowhere near the magnitude of the one of what we're dealing with COVID, it slid under the radar. Nobody really complained about it because nobody was really applying for claims under that policy itself. So the exception slid in, nobody noticed, and since nobody was effectuating it, it's been sitting there. Well, now we've got a scenario where a bunch of people have been paying a lot of money for these insurance policies. Business has been interrupted. Everybody's business has been interrupted, but they're getting denials across the board from these big shot carriers based upon this minute little exclusion for virus. So one of the things, and my law firm is actually, we have over 250 new clients for this particular issue, is we are filing suit not based on the fact of that exception, but based on the fact that that exception doesn't apply because the business interruption is based upon a moratorium set forth by the federal, state, and local governments. That's how we're going to try and work around that. Because at the end of the day, everybody's paying out. Tenants, they're hurting. Workers are hurting that are furloughed or laid off are hurting. Landlords who aren't collecting rent, they're hurting. Mortgage lenders who aren't collecting mortgages are hurt. But who hasn't really taken a hit yet? The richest people in the room, the insurance companies. So I think that's going to be quite interesting to see how that plays out.
That's a great case for you guys too. So, and I we love hearing that. And here's the thing, you mentioned a really great thing, and I want to switch gears into that for a minute here, Sky, is this landlord-tenant issue.
Sure.
I'm a landlord. I've been a tenant. We've all probably been there at some point in time. I know many people on this call own properties right now. So
Sure.
In this time right now where we have the potential for a tenant to be like, hey, I can't pay you. What do we do as landlords? And
Or
from
hold
an
on,
attorney,
Brad, even worse is I can pay you. I haven't really felt interruption, right?
yep.
But all my friends aren't paying. All my neighbors aren't paying. I'm looking at these blogs online that says I don't have to pay.
Yeah, the news
Right?
told me that I don't have to pay my rent this month. So, so what do we do with that? And how can we either get your assistance in dealing with our tenants, or, just dealing with our tenants?
Well, something important to understand, and let's quickly take it perhaps from a tenant standpoint, because I like to play devil's advocate, right? And then we can switch over. If I represent a tenant and there has been legitimate interruption, it is not okay for me to simply send a letter saying, sorry, we ain't paying. Or for my tenant to directly contact landlords and say, sorry, we're not paying. There are clear guidelines that have been set forth in these hastily constructed moratoriums that indicate that you have to prove up financial hardship. You have to show that your business has been shut down. I mean, I've got several mortgages. I've got a huge lease on this place. I haven't, to be honest, I haven't felt interruption. I've just simply pivoted the type of legal counsel I'm providing, and I'm paying on every single debt I got.
Really
And
quick,
so,
before we go down that road, I'm sorry to cut you off.
sure,
What kind
no.
of proof would they have to provide?
The COVID handbook that I emailed you will tell you exactly what it is you need to provide and within the time frame. Okay.
And I have that handbook, guys, and Schuyler has given me permission to send that out. So I will provide you guys with the handbook that Schuyler sent to me from his office that kind of outlines some of these things as well.
And I think, again, my firm put over 30 hours into doing legal research, attending webinars, et cetera, to put all that information together. Because what's tough, Brad, is when you get into too much detailed minutia on all these other issues, it's just, you kind of lose the big picture. So ultimately, I think what needs to be conveyed here is that if you're a tenant, don't sit on your hands. You need to communicate. But that also goes with the landlord. If I'm with the landlords that I represent, if April 1st came and went, or April 5th more specifically, and there wasn't payment made, we affirmatively reached out. Okay. And on the folks that have financial hardship, but that it hasn't been catastrophic, meaning that they've had a reduction in business, not a complete elimination, or if it's just simply a business with a lot of reserves that can afford a couple months of minimized income or none. What we've done in that situation as representing landlord is I've negotiated reduced monthly payments. So let's say that tenant has a $5,000 a month lease, and I know my client's property debt service, his mortgage, his property taxes, his hazard insurance on that investment property, on that commercial building, let's say that's $3,000 a month, okay? Then really what I'm targeting to do for my client to the fullest extent possible is getting them that $3,000 a month so that my client's not falling into arrears with their lender, okay? And then what I'm doing is I'm either tacking it on into the back, deferring it one way, shape, or form.
And that brings up a really good point too. So, okay, I'm a landlord. My tenant pays $3,000 a month. I know that my expenses are $2,000 a month. And I say, okay, Mr. Tenant, I get it. You've proven to me that you're on hard times. I'll take $2,000 a month, but your rent is still $3,000. I'm going to take this $1,000 a month for the next 6 months, 8 months, whatever. And then we'll divide it up and add it to your rent after that time period. Is that your suggestion? Or
Well,
and then
again, it's a bit too fact specific, Brad. I mean,
okay.
It's one of those scenarios where, depending on the circumstance, how many months do we have left in this lease, right? Is this a tenant? You had two types of tenants, right? You got the ones that were always trouble, they were always 5 or 10 days behind, pre-COVID, okay? I'm going to treat those tenants a lot more harshly than I am the ones that have been there for 5 years, never made a peep, always making their payments timely, have no inclination that they want to move, those folks, I'm going to give them a lot more latitude because there's goodwill that's been created there, and there's the faith that, you know what, if we revise the deal, if we agree to an abatement or a forbearance of rents for 2, 3, 4 months, I don't have to go chasing that money. If you find yourself in a situation where you had a tenant, and I'm dealing with a lot of these too, that were a problem to begin with, those are the tenants that, even if they didn't have interruption with COVID, they're probably not paying anyway. And those are the ones you give them your 3-day. And again, as soon as things open back up, oftentimes I take a hard line and move forward with the eviction process itself pretty quickly.
So with those so anybody who's got a bad tenant or anything like that, you've got somebody that knows is going to be a problem. You start that 3-day right now, get it ready, so that as soon as the moratorium lifts up, you're ready to go.
Exactly.
Let's say you have a great tenant and they're good, but then all of a sudden, you get to the end of their lease and they move out and they still owe you $3 or $4 grand. I mean, are we talking having to go through like a small claims court type of situation because you've given them an abatement?
Well, again, a lot of difficulties with collection post conclusion of the lease, okay, are largely based on whether or not proper due diligence was done on the front end, right? Did they have an 800 credit score, right? Did they have any other judgments against them? Did they rack up their credit cards? Did they have consistent employment? And there's a reason, Brad, why I ask for pay stubs when I'm reviewing a potential applicant for one of my higher net worth properties, okay? Because let's say I've got to sue this person, right? And I get my judgment. Let's say they allow it to default, okay? And I've got a default judgment for 25 grand. Well, if I've got a pay stub and I got a bank statement from maybe 2 years ago, maybe I just go ahead and issue a notice of garnishment and a bank levy to those two institutions, give it a shot in the dark, right? And so a lot of the difficulties in collecting on the back end are really symptomatic of, perhaps errors that were made on the front end. But at the end of the day, security deposits are not intended for missed rent payments. And I do the best I can with my clients when I'm negotiating with a tenant, not to allow them to rely on that. One thing you guys will see a lot is I want to use I want my security deposit to go as my last month's rent. Well, it doesn't work that way. Unless you've been in that property and conducted inspections and point blank, this tenant's been treating the property great and you have nothing more than normal wear and tear, then maybe you do that in extraordinary circumstances. But if you're allowing them to use the security deposit, then there is no security deposit, right?
I agree with you. I think at that point, you're kind of asking for trouble. I just want to see really quick, does anybody on the call have a tenant-specific question or landlord question that they'd like to ask Skye?
I do. Hi. So my tenant hasn't.
Christy, we can't hear you very well.
You hear me now?
Well, that was a little bit better.
I'm trying to get closer to the computer. My tenant hasn't provided any proof or anything, and they're just not paying, and they're avoiding me. So should I send out some sort of letter? Like, I don't really know what legal steps I should be taking, or should I hire a lawyer to do it?
Well, Christy, are you the owner or property manager?
Owner.
Okay. A couple of things you can do, okay, is was there any defaults or any problems pre-COVID with this particular tenant?
No, I mean, they always paid on the 3rd, like they never paid on the 1st, but they always paid.
Okay. What I would do is Brad will circulate my handbook and it'll identify certain things tenant has to provide, okay? Probably before necessarily going the route of engaging a lawyer and assuming those costs, even me, what I would do is, send them a formal letter saying, you missed your payment. Presumably it's related to financial hardship associated with COVID. In accordance with City Emergency Moratorium Ordinance XYZ, please provide me the following. okay? And the reason why that's important is because those financials go back to what I just talked about, where if they've been there for 4 years, maybe they have a new employer, maybe they have a new bank. And it's always good as a landlord to have information on where your tenant keeps their money and who employs them. Because, folks, when somebody trashes your place and up and leaves town, going and
Mhm.
trying to chase them down can oftentimes be way more headache and cost than it's actually worth. So again, it's important to have that information.
Yeah, it's a
Okay.
great question too, and I appreciate that because yeah, so making sure again, if your tenant's not going to pay, look, here's what I need. I need a copy of your bank statement, or not bank statement, but what was your last paycheck, that sort of thing, so you have some information on them.
And then
Any other questions, really
and
quick?
then
I just-
Christy, one last thing too is if they're non-responsive to that, then again, I would quick sooner rather than later engage. It's a very nominal fee. It's I don't know, I imagine my firm's probably charging around $250 to $300 to send a formal attorney letter and with a 3-day notice to pay or quit. Okay. Now understand, of course, generally speaking, pre-COVID, I send my 3-day notice to pay or quit. On day 4, I file my unlawful detainer action summons. Well, that's kind of where we're in a jam right now. But you still want to get that shot across the bow now. I would strongly urge you all not to wait 3 months of 3 months of no payment and then issue a 3-day notice. Because one of the things I'll tell you is you file a 3-day notice, you file an unlawful detainer action, and you find out later that you screwed up on the 3-day notice. Guess what you got to do? Start it all over again. And
Mhm.
unlawful detainers, the unique thing about unlawful detainers is time is money. You are rarely in an unlawful detainer action unless your tenant isn't paying. And when your tenant's not paying, you're really, what I advise most of my landlords is, how do we mitigate your cost? I can't squeeze water out of a rock. If this tenant's judgment proof, then what we need to do is we need to get them out of that property as soon as possible and get a good tenant back into that property.
Great explanation. Go ahead, Janet.
Just a quick question, and I wanted to understand if you are able to negotiate some type of proportional
Sure.
rental payment, as the example Brad gave. How do you document that? Is a letter sufficient? Do you have to amend the lease?
I would generally handle it either by a formal revision. I would probably handle it as an addendum. That's kind of depending. Essentially, here's how my answer to you is: if the original lease was competently drafted, then I'll generally do it as an addendum. Okay. If the lease is very vague on some important terms, prevailing party attorney's fees and costs, notice, things of that nature, I'm going to probably tell my client, look, you did the legal Zoom, a landlord tenant lease agreement. If I have to sue on this actual document itself,
Mhm.
we could end up getting them out of there, but not having my attorney's fees covered. I think we take this opportunity to propose a revised lease addendum settlement agreement where it allows me to kind of throw in additional provisions in addition to the abatement.
Good consideration for.
Because now what you're doing is we're creating a document where I essentially rewrote your lease. I gave you a second bite of that apple. So if we have to sue, we're not suing on that one pager, right? That's full of holes. We're
Yeah.
suing off of my new revised settlement addendum. That's bulletproof.
Got it.
And I have an addendum that I could supply if anyone needs it. Just feel free to reach out and ask me. Nice. Any other questions, landlord, tenant type of stuff? Go ahead, Joanne.
Yeah, I just have a real quick question. Unit 1 has always been on time and doing great. Unit 2, not so much. Can you make better arrangements for
Yes.
one without the other, without worrying about being sued, having done so?
Yes, what you cannot do, but this goes across the board regardless, is you can't treat Unit 1 and Unit 2 different based on a protected class, right? Race, religion, creed. So you essentially, as long as you're not discriminating, okay? And by the way, charging unit 1 and unit 2 different rates, okay, on its face is not discriminatory, okay? It could be that unit 1 has better credit, okay? If you apply for a loan and somebody else applies for a loan and you've got awesome credit, good income, and somebody else has crummy credit and not a very good credit history, are you guys going to get the same interest rates? No. So as a landlord, really what you charge can be largely premised on your relationship. Does this tenant, are they the type of tenant when a light bulb goes out, they go to Home Depot and they put a new one in? Or do they call you every time the garage door remote battery dies? Okay. So again, long story short, folks, is as long as you're treating everybody equally in the eyes of the law, and by the eyes of the law, I mean you're not discriminating based on a protected class. Again, you do not need to give Unit A the same terms as Unit B, even if it's the same layout.
Thank you.
Awesome. And then let's talk really quick about, I know when I have clients, I always tell them when you purchase a property, you should put it into a will or a trust, that sort of thing. With everybody worried about family members getting sick or somebody, you know, whatever, what's your thought? I mean, obviously people should have all of their properties and other things in a living will or trust if they don't already anyways, but what about doing this now and during this time?
Well, this, you probably hit on the most important thing I've been dealing with lately, okay, is business interruption's important, but I just met with a family this morning who had their grandmother was at the Avocado Acute retirement home, okay? And you guys can look up on Channel 10 News and see that there's been 11 deaths in that facility. Well, that woman had a property that was not in trust and she didn't have a will. So we're going to have to, and the property was paid off, and we're going to have to take that and go through probate. It's going to be a really lengthy process. It's going to cost, at the end of the day, about 5 to 10% of the value of the estate itself. And it's going to be a complete and utter nightmare. And it could have, in addition to that, they did not have a POA, a power of attorney. So just being able, for example, I'm going after and I'm suing I plan on suing the assisted care facility because there's evidence that one of the nurses was aware they were sick and they did not keep that person in quarantine long enough to confirm that they were healthy again before they reintroduced them to the entire, population of this retirement home. But that aside, point of my tirade being is you really need an advanced healthcare directive. You need a will. And if you own real estate and you have any heirs, family, particularly children, you really, really need a trust because otherwise it's going to go through probate. It's going to be a nightmare and they're not expensive. They're really not expensive to create.
I mean, what are we talking? I mean, obviously, every person's different depending on assets and things like that.
But you're usually, for a competent representation, you're looking at between $1,500 to $2,000 for the package, for the will, trust, advanced healthcare directive. Now, a lot of our clients, what we do is they had a trust. The trust is 20 years old. Okay, so sometimes it's just simpler. Revise the whole darn thing. But other times, what folks don't understand is a trust is a box, okay? You go, you create the trust document, and you create the box. But if you don't take the asset and put it into the box, if you don't transfer title of that property properly into the trust, then it's not subject to the trust. So you could have a trust, screw up the transfer, and end up having to go through probate, okay? Which is why, again, I tell folks, you can pay me about $1,800 to do your trust, or you can go to LegalZoom for $99 and call me later to unscrew your trust, and it'll be about $10,000. So pick your poison.
So very true. I wanted to see, did somebody else have a question? I thought somebody had, in regards to either the trust or in regards to landlord-tenant, if I move too fast over that. All right, I think we're good then. I just think that having a will and trust is one of the most important things. Something that we touched on the other day, Sky, was bankruptcy. Are you seeing a lot of that going on right now? And what happens if we have, like, again, this kind of goes back to the tenant thing. What if we have a tenant that's going to try to do bankruptcy or something like that? I mean, how do we handle this?
Well, my website had 72 inquiries in the last 5 days on bankruptcy. Okay. And haven't even reestablished bankruptcy as a tab on my website yet. Okay. Because over the last 5 years, my firm's averaged maybe 1 or 2 bankruptcies a week versus the Great Recession where we were having maybe 10 a day. So point of my tirade is we're going to see a huge resurgence, probably like we've never seen before, of bankruptcies. I don't enjoy it. We're good at it, but I don't like it because it is what it is. It is a very, very difficult situation. But the thing with bankruptcy, what's most important about bankruptcy is timing. So to answer your question, I've spoken to a ton of people about bankruptcy. Out of those 70 people that have consulted, have I advised any of them to push the bankruptcy button now? No, absolutely not. So I would, regardless of how much your credit cards are racked up, how late you are on your mortgage, why would I not advise you to file bankruptcy right now? Well, I wouldn't advise you because none of your creditors can foreclose. None of your landlords can evict you. So it would be better to postpone oftentimes to capture as much debt. Let's say you've got overdue taxes you owe the state franchise board and the IRS, and those delinquencies are over 3 years old. Well, I can capture that if we wait another couple more months. Okay. So what's critical, folks, about bankruptcy is timing, and making sure, again, be very, very careful not to go with a mill firm. Okay. The people oftentimes that are advertising the most in the legal field are the folks that are spending a lot of money on advertising and not a lot of money on where it should be, on paying their associates and their staff, the folks that are actually doing the work for you. Okay. So if you see somebody's name on a billboard or a bus stop, okay, please think twice. And I mean that in all seriousness. Good lawyers, generally speaking, don't do much advertising, and that's across the board because they don't have